In a significant ruling, a 7-judge bench of the Supreme Court has, by a majority, has held that subclassification of scheduled castes or scheduled tribe is permissible to grant separate quotas for more backwards within the SC/ST categories. The bench was led by Chief Justice of India D Y Chandrachud, who had on February 8, 2024 reserved its judgment on the reference made to it. Now, this verdict overrules a 2004 judgment in the E V Chinnaiah versus State of Andhra Pradesh case, which said there cannot be a subclassification of scheduled castes and scheduled tribes for the purpose of reservation. This is the big breaking news that's coming in. Right now with me in the studio is our legal editor Ashok Bagaria. We'll just try to understand this and set this more into perspective. Well, Ashok, a very good morning to you. Very firstly, I think this also comes in at a crucial time given the politics around caste census that's also underway in the parliament of our country. But just to get into the depths of the very particular judgment that's come in, as well as what was said by D Y Chandrachud back on 8th February and the previous case that we're also referring to with regards to Andhra Pradesh. If you could just take us through the timeline.
Well, what really happened is that today the Supreme Court has delivered a very significant judgment. This comes almost 75 years after the Constitution was framed and provisions for reservation for scheduled caste and scheduled tribes was introduced in it. Now, after so many years, what the Supreme Court has said that when the states are giving reservation to the members of the scheduled caste and scheduled tribe, it can subclassify some castes within the scheduled caste and scheduled tribes and give them preferential treatment in terms of public employment and admissions to government institutions. So far, all the castes within the scheduled caste and scheduled tribes were being given the same kind of treatment, and as a result of it, what was happening was that there were certain communities and castes within the scheduled castes and scheduled tribes which had actually bagged all the benefits of reservations to the detriment of other castes. Now, what had happened was in 2006, this Punjab government had enacted a law where it said that preferential treatment will be given to the Valmiki caste and the Mazhabi Sikhs who fall within the scheduled caste category, and they will reserve 50% of the reserved seats for these two castes. So, what it did was it said there will be a quota within a quota. This matter went to the Punjab Haryana High Court in 2010. Punjab Haryana High Court strikes down the law as bad in law. Matter comes to the Supreme Court. It's pending for the last 14 years, and the Supreme Court matter was referred to a 7 judges in 2020, and in the last 4 years this matter was considered by a bench of 7 judges. Now, they had to consider whether such creation of a quota within a quota was permissible by the Constitution of India. So, now today, by a majority of 6:1, the Supreme Court has held that yes, it's permissible for the state governments to give preferential treatment to some castes within the scheduled caste by the states, but there shall be a criteria which will be followed as to how you identify these castes who are given preferential treatment and how it shall be done. So, the first thing it said is that when you are creating a quota within a quota, it can only be done on the basis of any empirical data which has been collected. Secondly, they said that very important things, generally they have seen that such kind of creation of quota within a quota is being done for political purposes. So, the court says that it cannot be done on political whims and fancies, and if such a law is enacted, it will always be open for judicial review. So, what happens as of today is that while the Supreme Court has permitted this quota system within quota, it will also throw open the doors for demands of other reserved categories seeking quota within quota.
Right, right, absolutely. In fact, if we are to get into the depths of the matter, let's also understand. I have three questions that were raised back in February as well with regards to the need of these subclassifications. One, questioning the very necessity, as I just mentioned, of the subclassification. And there was another question raised about whether scheduled caste is a homogeneous category. These were all concerns that were raised back then. And are states competent to create subclassifications within reserve categories? So what this also might end up doing is create some, do you think there might be room for a bit of a confusion that might be created at this point with this particular judgment?
Well, what this judgment basically does is that in 1991 there was the Indira Sahni judgment, which was delivered by a bench of 9 judges. Now, at that point in time, these 9 judges were dealing with reservations for the socially and economically backward classes, which are also loosely called the OBCs. And at that point in time, it was argued that whether there were certain castes or certain classes within the OBCs which could be eliminated or which could be moved out because they had reaped the benefits of reservation and now constitute the creamy layer within the OBCs, whether it was permissible or not. At that point in time, the Supreme Court's 9 judges said, yes, this kind of a subclassification is permissible. The creamy layer idea came and this whole idea of subclassification was approved. Now, today what these 7 judges have done is that they have basically said that we are going by Indira Sahni. Indira Sahni had approved subclassification. We are also going by that judgment that subclassification is permissible, and it is not just confined to the OBCs, it's also permissible within the scheduled caste and scheduled tribes. But why they are approving this is because they have recognized in this judgment the ground realities, and the ground reality is that there are various castes, communities within the scheduled caste and scheduled tribes who have not got the benefits of reservation even almost 78 years after the constitution extended to them. So what has happened is that these sections, these castes, these communities remain unrepresented in public services. Their children do not get admissions into government institutes, and they continue to be stereotyped or stigmatized by this idea of untouchability and backwardness. So keeping this in mind, the Supreme Court has said that this is permissible. Now, coming to your second question of whether the scheduled castes and scheduled tribes are a homogeneous group or not, the answer is a straight no. No combination can be termed as a homogeneous combination, and especially the scheduled castes and scheduled tribes, because there are all kinds of people who have been rather stereotyped and who have been at the receiving end and branded as untouchables. And even within one state, there is a difference as to what particular caste is considered to be scheduled tribe. Scheduled caste in one particular district may not be a scheduled caste in another area. So that way, SCs and STs are not a homogeneous group, they are a heterogeneous group. But still, despite the heterogeneity, the Supreme Court said that this idea of creating a quota within a quota based on empirical data of backwardness and inadequacy of representation is permissible.
Right. In fact, I think here I would like to ask you a speculative question, a little, in fact, going into the politics of the matter. Do you think this judgment actually ends up pushing forward the demand for a caste census in the country at this point?
See, that is a political question, as you say. That's a political question. Many state governments have been demanding a caste census. But now, what is more important is that this will create internal conflicts within the states which have reservations for SCs and STs, where some castes and communities will start demanding preferential treatment, saying that, look, for so long the Constitution has given us reservations, but despite that, the benefits of reservations have not reached us. Now it is time that the state governments, the central government does something to ameliorate the condition of these castes, which despite getting reservations on papers, has not got reservations.
Right. So I think it's a rather interesting juncture that we see such a judgment come in at. Definitely, that is a bit of a political question that remains to be answered, whether caste census does get an impact from this particular judgment or not. But well, this is quite an important breaking news that we brought to you, a historic judgment that's been declared by the Supreme Court of India.